Good morning, everyone. Welcome back to another Monday morning edition of Beyond the Soundbite. I am Carol Williams, Managing Attorney of Williams Immigration. So, I like to dive right on in. This Monday morning is going to be all about travel, whether it's domestic or international, coming into the U.S. or just traveling around the U.S. So the first thing I want to talk to you about is if you are planning on applying for a visa, which many of you will be, you know that our U.S. Department of State oversees all of the consulates and the embassies outside of the U.S. They have issued a policy change that will take effect September 2nd, which will change the timing of visa applications and the way that they are processed. So as of September 2nd, the number of people that will be eligible to apply for a visa and not have an interview, so in order, having those interviews waived, will be cut back drastically. So in general, most people now, starting September 2nd, will need an interview. You may recall the consulates had a massive, massive backlog. And so one of the ways that they were working through that backlog was to institute a waiver system whereby if you met certain criteria, you did not have to actually go into the consulate and go to an interview, which opened up a lot more interview slots. So the Department of State is rolling that back as of September 2nd. So in general, most people are going to need now to plan for an interview. So if you are applying for an initial application, if you are renewing in the same visa category, so let's say you're applying for just a renewal H, you get that approval notice in the US, you go to the consulate, and this may be like your second or third, or maybe even your fourth H visa stamping, you will now need an interview. If you are a minor, you will now need an interview. So very, very, very limited exceptions. Some diplomatic categories, so your A's, your G's, your NATO's, so some of those will be exempt from interviews, and some very, very narrowly defined B1, B2 visitor renewals. But in general, I would like everyone to think that they are going to have to do an interview. So what does this really mean? So when the rubber hits the road, it means that when you're planning visa stamping overseas, you're going to need to budget in more time than you did the last time you went. Even if the last time you went, you had to go through an interview, budget more time. So if many people plan to travel over the end of year holidays, they go home, and then they want to go quickly into the consulate, pick up a visa, and then come back in. So we're going to take quickly out of that statement this year, and we're going to plan ahead as much as we possibly can. So you're going to want to plan ahead for that. One way that you can plan ahead for that is using the visa appointment wait time website that the Department of State has for us that helps us plan. And the third thing you're going to want to do, which sounds a little counterintuitive, is pack a lot of patience. With any policy change, especially this one being so close to the beginning of a holiday season, the end of year holidays, when a lot of people are going to want to travel, a lot of people are going to want to get visas, you're going to have to pack some patience. So just keep that in mind. If you are going to need to get a visa after September 2nd, chances are quite high that you will need to go through an interview, whereas you may not have needed an interview the last time. So we're going to switch now to domestic U.S. travel. So if you were traveling in the U.S. For years now, we have had to take off our shoes, take off our belts, take off our jackets, remove everything out of your pockets, stand on the little yellow feet, raise your arms, all the things by way of security in the airport, which is run by TSA. So we have now seen a slight shift in those safety mechanisms that they are now using. We've seen them evolve over time. So they're, simply evolving currently. So now you no longer need to take off your shoes. I have just flown week before last. So I was just on a plane very, very recently, did not have to remove my shoes in order to go through TSA. Removing electronics is still a little hit or miss. That wasn't one of the things that they, had sort of this blanket rule about, or this new blanket policy. So sometimes you're going to have to remove your electronics, put them in a separate bin. Sometimes you're going to have to remove them. They're going to have to be in a bin all by themselves. Other times you don't have to remove them. So as always, you're going to want to pay attention and listen to the TSA agents as you go through. And another massive change that we've seen instituted a couple of months ago is that you must now have a real ID. So the real ID has biometric information in it that is available to folks who have the right scanners and can read the biometric information. So you want to make sure that you have a real ID with you. If you're not quite sure if your current ID meets the real ID requirements, even if it is a government issued ID, the TSA website has a page devoted to real ID and the documents that are approved. So if you need that page, you can feel free to DM me. I'm happy to send that to you. The next thing I want to talk about this morning is when you're traveling in the US, when you're traveling into the US and you are not a US citizen and you are not a green card holder, and you're given what's called, now it's electronic. It's an electronic I-94 card. When I started practicing, it was an actual white card in your passport, so I still call it a card out of habit, but it is electronic. And the I-94 tells you a few things. It tells you your name, it gives you your passport number, and some super important information. It tells you the status that you were admitted in. What visa status were you admitted in? And what is the expiration date of your stay in the US? So those are two very key pieces of information. So every single time you come into the US, you want to go online and you want to download your most recent I-94 card. You want to check it, make sure that your name is spelled correctly, that your country of birth is spelled correctly, that your passport number is correct, and the status that you intended to enter the US in is correct. Mistakes happen. I have absolutely had folks call me and say, oh, it seems that I was admitted as a visitor instead of an H-1B status, or instead of an L status, or instead of O-1 status. This can and does happen. One, because there are humans, there are CBP officers at the airport, and we're human, we all make mistakes. And two, if you happen to have two valid visas in your passport. So oftentimes people may have a valid unexpired visitor visa in their passport, as well as, let's say, an H, an L, or an O in their passport. So, and some people get super nervous when they go through passport control and they don't want to say anything. But if you see an officer lingering on your B1 or your B2 visa, but you know that you're entering, that you want to enter back in the US in H-1B status, it's perfectly fine to tell them that you have another valid visa in your passport and, and you're entering on that visa. If you enter on the visitor visa, that doesn't give you work authorization. If you are entered on your H or your L or your O, that gives you work authorization. So you want to make sure that you're checking your I-94 card every single time you come into the country. And so some of my clients who travel a lot say, but Carol, every time? The answer is every single time, because you don't want to find yourself, 6 months down the road, maybe where you have a lull or break in your travel, and then you realize, oh, I was entered as a visitor and I shouldn't have been. We can certainly work to correct that, but correcting it goes a long way if we are able to correct it quickly. And so make sure that every single time you are entering the US, you are checking your I-94 card, especially if you need work authorization when you enter. And the last thing I want to talk about in terms of travel today is a new shared agreement between Chile and the US. So those two countries, Chile and the US, are working and have signed a new letter of intent to continue to share criminal and biometric information. And so it is, according to DHS, a way to make sure that criminals and folks that have criminal histories are not being allowed into the US. And so there was training last spring on this pilot program for Chilean law enforcement. But I want to be clear, right? The sharing of information in this manner is not new. The US shares criminal info with other countries. A lot of what I sometimes see in my practice is information shared with the border up that the US shares with Canada. I typically tend to see people who reach out to me who have been denied entry into Canada because of a criminal history that they have here in the US. I see that happening a lot around major festivals, major concert times in Canada. People in the US want to go up there, and Canada and the US share that criminal information, and Canada says no, you are not allowed in to Canada. So this is, while it may seem a little jarring and a little alarming, this is not new. The US absolutely shares information with other countries. And so in terms of travel, that is all I have for this morning. But the last thing that I want to talk about this morning are my H-1Bs. So in speaking with colleagues, we have seen where individuals who have left their H-1B employer, are in their 60-day grace period, are being issued NTAs. And NTA stands for Notice to Appear. It is the first document that you receive when you are being placed into deportation proceedings or removal proceedings. The theory behind why the NTA is issued is it is a claim that you have left your H-1B employer, you are now in the country out of status and undocumented. Therefore, the Immigration Service is putting you into deportation proceedings. I think that argument is a teeny bit flawed in that if someone is in their properly authorized 60-day grace period, they are not in the US out of status. They're in a grace period. So we've had some colleagues who have had to fight these NTAs and go to immigration court and really kind of explain what happens on the non-immigrant side of the immigration house to the immigration judges. So if you are planning on leaving your H-1B employment, if you are planning on terminating someone who is in H-1B, I would highly recommend that you have a conversation with your immigration counsel about the possibility of being issued an NTA and what that will mean, and how you all want to approach that if it happens. So I did want to mention that, but that is all I have for this Monday morning. Have a wonderful rest of your Monday and a great rest of your week. If you have any questions about terminating H-1Bs or travel in and out of the United States or getting your visas, feel free to reach out to us. We are happy to have a conversation and help. I will chat with you next Monday. Bye.